Good afternoon. Welcome in, Butterfly, Eliza, Rachel. Good to see you guys. Sound check. Everything sound good? The stream didn't shut down 15 times before I tried to go live, so that's a good thing. Let me pull up the stream on my phone so I can see the chat because it's going to take its time over here. Check. Everything sound good? Okay. Hey, Butterfly, can you hear me okay? Okay, awesome. Sounds great. Good deal, good deal. This is not going to be a terribly long live. It is a long document to get through, but we also want to go over to Joe's channel in a little while to watch his presentation on the LA fires that we were talking about yesterday and that he spoke of this morning on his live, on the latest in the Lori Vallow document that came down, a couple of documents actually. So I guess you guys could tell there has been a motion to continue in the case against Brian Kohberger in the Idaho 4 case, and we're going to take a look at that. And we're also going to take a look back at his motion to strike the death penalty, because that's where a lot of this started. Yeah, they cite the Dateline stuff in this motion, but that's a small portion of the overall motion, right? So we'll look at the impacts that these different things may have. Because this is such a high, it's not that it's a high profile case, it's a death penalty case, right? So there's a lot more at stake for the defendant and for his attorney. And so, yeah, there's a lot of things she brought up in this motion that she brought up a long time ago that we're going to take a look at as well. Welcome in, Nina. Hi there. Welcome in, everybody. I'm enjoying the break today. I didn't have to get up and go early, so thanks, Bev. We could have used the break, come to think of it. So don't know how your jurors are feeling about it, but I'll take it. Welcome in, Joy. Your name just brings me joy every time I say it. Makes me want to go out and sit in the sunshine and find my joy, which I had to do yesterday. Lord. And again at 3 o'clock this morning, I went out and found some more joy touching grass. But it's a beautiful day. You guys go soak it up if you can. When life gets overwhelming, put it all down and walk outside for 30 minutes and just sit. I'm fortunate I have birds all around me in the country up here, so I can go out and sit and listen to them. Let me pull up my other screen so I can get ready to present what I need to present here. And we'll get started on this document. If I hit the right button, I'd be doing really good. Okay. Motion to continue. All right. This thing's not wanting to cooperate this morning. Okay. I want to look at it this way. It's telling me how to view it, and I'm like, no. All right, here we go. Now, share my screen up here and pull it on up. Welcome in, Bullets and Bling. You go right ahead. We've missed you as well. I've missed a lot of you guys who aren't tuning into the Reed case. Trust me, I miss you guys. I kind of wish I was there with you sometimes. Whoa, boy. Okay. All right, let me make this a little larger so I can see it because I'm darn near blind. And you guys can see that okay? All right. Yeah, everybody, thanks for coming in. If you don't mind, please hit the like button. Subscribe. We'd love to have you. It's free to do so, and it helps us out. It helps the channel out, and I do appreciate all the support that we have been getting. It means a lot to us. It really does. We work hard over here to try to get the information out. And thing about this Kohberger case, when I set out to, I was following this case before the arrest of Brian Kohberger, right? And I made a conscious decision when I started streaming that I was going to try to handle this case a certain way. And I wanted to really present documents and deep dive the documents because there was just so much out there um, with this case in the past. And so we're going to take a look at this document and see what's really in here and how much weight does it hold and how will that Dateline leak impact the case. Because in all reality, there's things on that Dateline we shouldn't know about yet, right? And so it's obvious somebody did some leaking, and it's the hardest part about all of that is the damage it would do to the case itself and the impact on the victims, right? Because if the defendant doesn't get a fair trial and something happens to cause a mistrial or majority of evidence gets suppressed, how's that going to affect your victims? How's that going to bring them justice, right? So we got to make sure that we're trying to give these guys a fair shake. You'll notice with my thumbnails, I don't do the AI Kohberger. I'm not going to use his images from the Dateline episode. I'm just going to use images taken of him in court um, because I don't want to be a part of the problem. I want to be a part of the solution. And those AI images don't even look like Kohberger. It's like, that's confusing, but okay. All right. Personal opinions aside. All right. 1 second, guys. I got to let the dog in. She harassed me right before I went live. I'll be right back. Okay, the air conditioner spoiled dog is back inside. I tried to warn her that Florida is on fire right at the moment. She wouldn't listen. She can go back out this afternoon and lay in the sun. All right. I'm not complaining because I'll complain in the winter. It's a beautiful day and I'll take it. Okay, so in the District Court of the 4th Judicial District of the state of Idaho, in and for the county of Ada, state of Idaho versus Brian Kohberger. Comes now Brian Kohberger, by and through his attorneys of record, hereby respectfully submits the following motion to continue to the substantial amount of trial investigation and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense. Any conviction and sentence resulting from a capital trial beginning in August of 2025 will be unconstitutionally imposed and therefore vulnerable to reversal on direct or collateral review. In making this motion, Brian Kohberger relies on his right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, his right to counsel, his right to present a defense, his right to confront witnesses, his right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments of the United States Constitution, Article 1, Sections 6, 7, 8, and 13. And then she has a big table of contents here because she's got a lot of moving parts in this large motion, right? The court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time to review discovery and prepare for the complex merits and sentencing phase unique to death penalty cases. That's a huge part of this motion. Mr. Kohberger has myriad constitutional rights during these proceedings, all of which are dependent on counsel having the time and resources to prepare. Oh, my phone was not on silent. Sorry. I thought it was. Um, Time and resources to prepare for a capital trial in accordance with established professional norms. In capital cases, the rights to effective assistance of counsel and a complete defense are amplified. Mr. Kohberger is also entitled to an individualized sentencing determination, a constitutional right that is uniquely reserved for defendants facing the death penalty. The right to qualified expert assistance as part of the guarantees to effective assistance of counsel in an individualized sentencing proceeding. Counsel's professional and ethical obligations in a capital case. Counsel's duty to provide effective assistance of counsel in accordance with the prevailing professional norms. The minimum requirements counsel must meet investigating for the merits phase of a capital case. Counsel must conduct an exhaustive, unparalleled life history investigation. That is the one thing she brought up many moons ago and said, I need to go back generations through Mr. Kohberger's family. And that's interesting, right? Analyze hundreds of documents and interviews and compile all of this information into a cohesive narrative for the sentencing phase. Because all the things that she talked about going back into that investigation into his entire family history would only be relevant during that part of the process. A full investigation is likely to lead to discovery of numerous mitigating factors that would be readily apparent from a cursory investigation. Mere identification of mitigating information is not the conclusion of the investigation. The alleged aggravating circumstances of this crime heighten counsel's obligation to conduct a full and complete investigation and prepare a presentation that could withstand adversarial testing. Counsel cannot review all of the relevant discovery and complete the necessary investigations prior to trial. The life history investigation is ongoing and requires, this is the part that when we get down to reading all this, the life history investigation is ongoing and requires additional time and expert assistance. Now we know from past filings that Anne did speak to his parents, and they went all the way back to Kohberger's childhood. And that's when they were started to determine something could be wrong, hence all the testing that took place recently. But is there more, right? What else is there in this family tree, so to speak? Thank you, Butterfly. Hope everyone is having a fabulous day. A continuance is necessary to remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline special and forthcoming book. Now, other than Howard Bloom, there is somebody out there writing a book. They've been writing the book for a while, and it is set to be released soon. Reversal is more likely than not in any case resulting in a death sentence. But I find it odd people are wanting to write books about a case that hasn't even ended yet. Like, and before it goes to trial, you're writing books about it. What can you write? This guy is suspected of this, and that. It's weird. Reversal is more likely than not in any case resulting in a death sentence. Continuance is reasonable and necessary under the circumstances. Now, I'll be honest, if I was a defense attorney, I would absolutely have to go up against any book being written about my client before a trial ever started. I'd be like, what are you doing? Can you write it later? This court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time to review discovery and prepare for the complex merits and sentencing phases unique to the death penalty cases. This court has an obligation to enforce the constitutional rights of all persons, including prisoners. They cite Brown versus Plata, and then they give the U.S. Title there. See, it's normal to cite all these cases. See also Robbie versus Connolly. Upon the state courts equally with the courts of the Union rests the obligation to guard, enforce, and protect every right granted or secured by the Constitution of the United States and the laws made in pursuance thereof. As detailed in this motion, moving forward with a capital trial in August will infringe upon Mr. Kohberger's constitutional rights. As counsel requires more time to review discovery, complete investigations, and prepare for trial. When considering this request for a continuance, the court must weigh the issues against the heightened need for reliability in death penalty cases. And then she cites another case, Woodson versus North Carolina. This elevated standard is essential because execution is the most irreversible and profound penalty. Indeed, death is different. Ford versus Wainwright is who they cite there. When the state seeks the death penalty, it imposes an extraordinary burden upon the court itself and defense counsel to ensure fairness, accuracy, and reliability of the trial and any subsequent sentencing proceeding. With a defendant's life stake, I think it should say at stake, the trial court must be particularly sensitive to ensure that every safeguard is observed. And they cite Gregg versus Georgia. And must take the extraordinary measures to ensure that a death sentence is reliably imposed rather than imposed out of whim, passion, prejudice, or mistake. And then she cites another case. Justice O'Connor's concurrence in Thompson versus Oklahoma reinforces the idea that trials must apply heightened scrutiny to decisions potentially leading to a death sentence. Among the most important and consistent themes in the court's death penalty jurisprudence is the need for special care and deliberation in decisions that may lead to the imposition of the death penalty. The Idaho Supreme Court, too, has emphasized the special safeguards and stringent due process protections that must be afforded in capital cases. State versus Creech. Creech entered the building, and we knew you were going to bring it, Ann. It's okay. There was a big problem in that case when they tried to carry out his death sentence. They couldn't, and the judge even spoke about this in the hearing when she brought Creech up. It was after his botched execution in Idaho. And it wasn't really botched, he was dehydrated. When you're dehydrated, your veins will collapse. Know from experience, they cannot get an IV in you. It is incredibly hard and aggravating, but that's what happened. So when she brought it up, the judge was like, yeah, but they're going to use a central line, is my understanding, right, when they try to move forward. So that case is still pending with how they're going to carry out his death sentence. The qualitative difference between death and other penalties calls for a greater degree of reliability when the death sentence is imposed. Emphasis in original, citing Lockett versus Ohio. Because proceeding to a capital trial prematurely is a decision that may lead to the erroneous imposition of the ultimate sanction, this court must consider and assess this motion under a heightened standard of due process. Mr. Kohberger has myriad constitutional rights during these proceedings, all of which are dependent on counsel having the time and resources to prepare for a capital trial in accordance with established professional norms. Now, considering that Ann Taylor's the top death penalty attorney in that part of Idaho, I would assume she already has a little team of people who work on routine filings during death penalty cases. But she needs more time and resources. But, 3 years we're going on now? In capital cases, the rights to effective assistance of counsel and a complete defense are amplified. Hey, Pokemon, Carrie, everybody welcome in. I think I've got a visitor. Hello, Mr. Schmo. Are you muted, sir? He's up here, but I don't know if he can hear or speak. All right. In capital cases, the rights to effective counsel of complete defense. Okay, we read that part. Sorry. All right, I got distracted. Whoops. The Sixth Amendment entitles Mr. Kohberger to the effective assistance of counsel at both the merits and penalty phase of the capital case. And then she cites another case, Andrus versus Texas. These are all U.S. Supreme Court decisions. In June 15, 2020, per curiam Strickland versus Washington, another case in 1984. Hello, sir. Can you hear me now?
I can hear you. Can you hear me?
I can hear you now. Crystal clear. We good?
We're good.
All right. So we just began diving into this document. Additionally, and concomitantly, oh my goodness, lady, you trying to get me to read big words right now. As part of the Sixth Amendment guarantee, I need new glasses, as well as his right to due process as protected by the 14th Amendment. Mr. Kohberger is entitled to sufficient amount of time to allow counsel to adequately prepare for trial and sentencing. See Powell versus Alabama, the 1932 case. Well, at least she's not going back to the 1800s where they did in one of their other filings. A defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. United States versus Ash, a 1973 case. Powell made clear that in order to preserve the accused right to a fair trial and to effective and substantial assistance of counsel at the trial, the Sixth Amendment guarantee necessarily encompasses a reasonable period of time before trial during which counsel might prepare the defense. Since he didn't have a bond and she never requested a bond hearing, I guess he's just good to go to chill there for as long as it takes. The Supreme Court has recognized that depriving a person of counsel during the period prior to trial may be more damaging than denial of counsel during the trial itself. And then she cites Maine versus Moulton. In a capital case, counsel must meet specific professional obligations to be constitutionally effective. The ABA guidelines outline the professional expectations and obligations for counsel in a death penalty case. These guidelines are not merely aspirational. They represent the current consensus on what is necessary or for effective representation in capital cases. The Supreme Court has consistently referred to the ABA guidelines to determine the prevailing professional norms for counsel's performance. For example, in Wiggins versus Smith, the court explained the ABA guidelines for capital defense serve as guidelines to determining what is reasonable and represent well-defined norms. Similarly, in Rumpella versus Beard from 2005, the court emphasized that this is the lawyer's duty to conduct a thorough investigation of the case circumstances and explore all avenues leading to facts relevant to the case's merits and the penalty of penalty if convicted, citing the ABA standards for criminal justice. I got a good drink of my tea, guys. One sec. Well, Rachel, she's the only death penalty attorney over there qualified, right? I mean, that's what she does. Most of her clients are death penalty, but it's up to her. She's got a nice team to help her out. Should be all right. Her other case is not near as complicated as this one by any means. Right, Mr. Mead? ABA guidelines expressly recognize the guidelines as the proper measure of the adequacy of attorney's investigation. Andrew versus Davis, 1092. I thought it was going to be okay. Never mind. I'm thinking about something else in my head as I was reading, and I shouldn't do that. My bad. Sorry, guys. So the ABA, guys, does stand for the American Bar Association. Standards and the like are evidence of these norms and guidelines determining what is reasonable. Internal quotations omitted. The Ninth Circuit is not an anomaly. More than 700 capital cases opinions cite the ABA guidelines. See the American Bar Association Death Penalty Representation Project list of opinions citing the ABA guidelines for capital defense. In addition to the effective assistance of counsel, Mr. Kohberger has the right to a meaningful opportunity to represent a complete defense. Holmes versus South Carolina. And then they cite the case of Crane versus Kentucky, noting the existence of fundamental constitutional right to a fair opportunity to present a defense. And then they cite California versus Trombetta. Under the Due Process Clause of the 14th Amendment, criminal prosecutions must comport with prevailing notions of fundamental fairness. We have long interpreted this standard of fairness to require that criminal defendants be afforded a meaningful opportunity to present a complete defense. Now, the fact that she does take all the DP cases, when there's not a DP case going on, she takes on all the regular cases, right? Because we know in the beginning she was appointed from the public defender's office to represent Xana Kernodle's mother in criminal proceedings. She was already her attorney. And then she got handed the Brian Kohberger case, and she immediately withdrew from the Kernodle case because literally anybody could have handled Kara's cases, but not anybody could have handled Brian Kohberger's. It's a conflict of interest when you're representing the guy accused of killing your other defendant's daughter. She did the right thing, right? In my book, and legally, she did the right thing. There was no shade about it. And people tried to make that such a big deal, but I guess they just don't understand how it works. This right has a number of sources, including the Due Process Clause for the 14th Amendment, as well as the compulsory process and confrontation clauses of the 6th Amendment. Then they cite the Holmes case. This right takes on special significance in capital cases. The right to present a meaningful defense must take precedent over any countervailing state evidentiary rules or other procedures that might be acceptable in the context of capital criminal cases. Now, you have to follow that she's not trying to use this stuff to take away his guilt or innocence. This is stuff they'll use if found guilty. So it's important to remember that, all this that she's talking about here. That might be acceptable in the context of non-capital criminal cases. Finding that South Carolina's state rule, which had been in place for more than 60 years, unconstitutionally infringed upon capital defendants' right to present a complete defense. And she cites another case there. Time and again, the Supreme Court has condemned procedures in capital cases that might be completely acceptable in any ordinary case. Mr. Kohberger is entitled to an individual sentencing determination, a constitutional right that is uniquely reserved for defendants facing the death penalty. Right, Eliza. This is how you do it, Lori. This is how you do it. If you want to cite a case, this is how you do it, ma'am. Because Anne's going to cite millions before the end of this case, including yours, Lori. About 5 times so far, she has cited your case in Idaho. It's quite normal to cite cases in court documents, right, that you need to refer to. Look at this decision, Judge. In that case, it could affect your decision in my case. The Eighth Amendment requires that a special sentencing proceeding permit individualized consideration of the defendant and the circumstances of the offense. Y'all, when I have to sit silent for all this time and Karen read, maybe that's what's wrong with me. I don't get to talk enough. Y'all know I like to talk. Woodson case, holding that the consideration of character of the defendant is a constitutionally indispensable part of the process of inflicting the penalty of death. Their character? Sometimes I go look up these cases they cite to really get a grasp on what they're talking about. You'd be blown away at some of the stuff you read. Roberts versus Louisiana is the case she's citing, holding that the state's mandatory death sentencing statute was unconstitutional because it did not permit the sentencer to make individualized determinations or access degrees of culpability. Individualized determinations, meaning every death penalty defendant is different, and they're all going to have different mitigating circumstances. You know, what happened in their childhood. Does it play a part in their bad behavior in adulthood or alleged bad behavior? Parker versus Duggar, 1991 case, holding that the petitioner has deprived his due process and Eighth Amendment rights to individualized sentencing where the appellate court failed to consider all mitigating evidence. As the Supreme Court noted in Edmund versus Florida, 1982, we insist on individualized consideration as a constitutional requirement in imposing the death sentence, which means that we must focus on relevant facets of the character and record of the individual offender. You know, a lot of people have wondered that, Carrie. Is she? I don't know. I was watching I binge watch 48 hours and stuff like that when I get bored with social media or done with it, right? And this case that I was watching, it was really crazy because of the guy that was the defendant, right? Were they intimidated by him? And it felt like they were. And so you don't I don't know. It's a hard call. But he told his client wanted to get up and testify on his own behalf, and the attorney said, "I told him, don't do it. You're completely unlikable, and no one's going to want to hear from you." And the guy didn't care. He's like, "No, I'm doing it anyway." And he did, and it backfired in his face, right? So he should have listened to his attorney. You're not likable. Don't go up there. Um, we can't recover from stuff like that. That's hard. I don't know. I think Ann Taylor is a top-notch defense attorney. If I'm going to evaluate this case fairly, which I intend to do from both sides of the table, right? If I don't let myself think a minute about what he did, I know he's charged with quadruple homicide. Everything else, I'm going to sit down besides that charge. What would I do for my defendant client if I was or a defense attorney? I'm going to do what she's doing. How far will it go? Will it work? That's anybody's guess. But they do have to have their rights fought for, because you don't want them to get ineffective counsel, right? So I don't know. Part of her, this is her jams, right? Why not? This is a high profile case. If she can get some of this stuff taken off the table for Brian Kohberger, Ann Taylor's made a name for herself. So we can't forget that either. She's not. I don't think she's a real timid lady. I think she's got
Yeah,
balls.
and she's at least as good as the ones that were representing Lori in Idaho,
Oh
and
yeah,
they said their best accomplishment was just getting the death penalty taken off the table for her.
exactly. That these lawyers come at this a whole different way than the average person, right? They got an end game. And Ann Taylor absolutely knows the more she can get accomplished for Brian Kohberger, the defendant, that's all going on her record and her resume. And, listen to any law tuber out there right now, all these big defense attorneys everybody's running and flocking to, they would be doing the same thing this Ann Taylor's doing. Ask them. So let's see. You want your defense attorney to go hard. Would Karen Reed have the kind of defense she's got right now if she didn't have a team willing to go hard for her? Look how hard the ones in Delphi went for Rick Allen. Right, Joe? They went hard. They put a lot on the line for that case, including
They
the
did.
reputation, including the reputations.
Right. And they're human and they made mistakes and they
They
readily
did.
acknowledge the mistakes they made. And
They
but,
certainly have.
but they came at it with everything they had and they went with what the best they thought was they had to
Yeah.
present.
I mean, I got to give them A for effort when it's due. It doesn't mean I agree with all their decisions or what they're saying, but I'll be honest, because I'm in Florida, and growing up, I thought death penalty was normal until I realized one day when I grew up it wasn't, and people had an issue with it. But it should be individualized, right? There are sometimes mitigating factors. Not saying that's an excuse for what you did, but say a really mentally challenged person, not a Brian Kohberger. I'm on a spectrum. We're talking about severely mentally handicapped people. There's sometimes that stuff does come into effect, and that's when it has merit, right? Um, as to, because honestly, in my opinion, if this guy's found guilty and they prove to me in a court of law, I don't care if he gets the death penalty or sits there his entire life. Either way, it's the same to me. Like It doesn't matter. Take the DP off the table, ma'am, if you can get it done. But guess what? He's going to spend the rest of his natural life and die in that prison of natural causes. Either way, it's a win-win. Some people think it's inhumane to do the death penalty, though. So the way I look at it is, okay, take it away. He'll still sit there for the rest of his life, right, Lori? Chad, now that's a different story. He's facing the firing squad in Idaho. When Chad's day comes and they don't have the damn intravenous drugs, Chad's getting the firing squad. Welcome to Idaho, fuckers. All right. Oops. Well, that's my channel. I don't take it back. No oopsies here. Oh goodness. Okay. As mitigating factor in any aspect of the defendant's character or record in any circumstances of the offense that the defendant proffers as a basis for sentence less than death. See? Sentence less than death. Don't mean get me out of jail for free. Just don't kill me, as Ann Taylor puts it in court. Bell versus Ohio is who she cites there, reversing death sentence because statute precluded consideration of the facts and circumstances proffered as mitigating circumstances. And then they cite Green versus Georgia, a 1979 decision, finding unconstitutional the exclusion of evidence at sentencing phase based upon Georgia's hearsay rule. Oh, that's interesting. A hearsay rule. I like them kind of cases. They're so cool to dive into because there's so many different freaking roads that could apply to that. Don't you get sick of hearing the hearsay rule, Joe?
Yeah, it's so complicated, and there are so many
Mhm.
exceptions to it.
Well, look
So
at they didn't let Charles Vallow's body cam video with the police interaction in because they called it hearsay. And I'm like, it's on video. The actual man speaking to an officer of the law on a official body worn camera. How's it hearsay? Because Charles was relaying things to the officer that he heard and knew. It wasn't direct. You know what I'm saying? She was picking up hearsay from Charles. That was the law behind them not getting that into the case.
right,
You think it didn't make a difference? Obviously, she was found guilty, but it would have had a bigger impact, I think, on the jury to go, whoa, this lady has lost her shit. I'm just being nice when I say it like that.
right, because that's what Charles said. She's
Mm.
losing her shit. She needs to
Did
be
he say
checked out.
that? I missed that. Go,
He
Charles.
didn't. He didn't say it like that. No. I
Okay.
mean,
All right. I was about to say, me and Charles and Kay speak the same damn language. And Kresha, my God, I think they're my secret family. Like they're my spirit family. How about that? Kresha's my spirit sister. Oh God, I love her honesty. She's tough as nails. All right. Finding that it was constitutional error for sentencing court to conclude that it could not consider the defendant's turbulent family history as a mitigating factor in deciding punishment. Now, that's a road right there because you know how many kids, if you ever seen a child or knew of a child, you knew in your heart of hearts that kid ain't got a fighting chance. That family's going to screw him up. I know kids like that. Skipper versus South Carolina, 1986. Holding that it was unconstitutional violation of Lockett for trial court to exclude evidence that defendant had adjusted well to incarceration between arrest and trial. Okay, I got to go back through this later and go look these cases up. Perry versus Linnall, a 1989 case. Now, remember, back in the early 80s, mid 80s, the death penalty was a super hot topic. You won't remember if you're not my age, but it was, especially here in Florida. When old Sparky started to malfunction and stuff, that was our electric chair. The people were like, "Oh, you can't use that thing. It's electrocuting people." Well, that was the intention. But okay, we'll adopt the different method if that makes y'all happy, right? Vacating death sentence because trial court's instructions to the jury did not allow jury to consider as a mitigating factor evidence of the defendant's mental retardation and childhood abuse. We put Ted Bundy to death, don't we? Stephen Stearns is here, y'all. Y'all all give it a shout out. Go Florida. All right. It sounds like I'm supporting the death penalty, didn't it? But I'm not. I'm just saying, do what you got to do to these guys. Lori Dumbbell, that's like the best shit. Why didn't we think of that early? Carrie, Joe, we have a new name for her. Joe probably stepped away.
No, I'm here.
Look, we got a new name, Lori Dumbbell. I like that better than any of them.
Yeah.
Married to Chad Dumbbell.
Yep. Chud.
And
Chud dumbbell.
Chud Dumbbell. That dude ain't no count, is he? He's just like a bump on a fucking log. Finding that Texas three-question sentencing format, in light of jury instructions and all circumstances of case, did not adequately allow the jury to consider mitigating evidence of mental retardation. Well, I thought you just said he was on the spectrum, and the judge done. They already said you can't do that, Ann. Everybody's on the spectrum. You can't do that. Tenard versus Dratiki. Relevant mitigating evidence is evidence which tends to logically to prove or disprove some factor or circumstances which a fact finder could reasonably deem to have mitigating value. Meaning the jury needed to be instructed on this defendant's childhood and traumas when considering the death penalty. Thus, a state cannot bar the consideration of evidence, and the sentencer could reasonably find that it warrants a sentence less than death. Maybe I should go to work over there in Idaho. I already know what they're going to say before they say it. I need to go count how many of these damn documents in this case I've actually read. When a jury is denied relevant mitigating evidence, either because counsel independently fails to conduct a complete investigation or because the court denies defense counsel adequate time or resources to conduct such an investigation, the defendant's right under 6th, 8th, and 14th Amendments of the U.S. Constitution, as well as the corollary guarantees in the Idaho Constitution, are violated, and any resulting death sentence cannot stand. Well, you've been working on his life history since the motion to strike the death penalty. And I have that document, and I have what you said in it. So you've had quite a bit of time, and we know you've investigated it because you thought it warranted further testing. And lo and behold, we got the OCD and the spectrum and all that going on now. And we walk funny, and we gaze, and okay. And you want the jury to be aware of all that. We get it. This is going to be, guys, a lot of the different things in here are going to get crazy as they go on. Yeah, see, Pokemon, the thing is, like, when you, the term mentally retarded, which isn't used anymore, but back then, there were a lot of kids that really were. They didn't, it was, I don't know what it was. It's kind of like autism today. There was just a lot. And I used to be a student aide in those classes, right? And work with those kids. And they were my age, but actually they were just a couple years younger. But they were really different, and they didn't think like we thought. Their whole thought process, some of them didn't know right from wrong. And they're very overly aggressive, like they're really strong, physically strong, and some of them are really overly sexual, but they don't know that it's bad. That's the kind of person they're talking about here, not a Brian Kohberger person, right? Totally, these people can't function in society without the assistance of someone, or are living in a home and things like that. But there were a lot of kids, unfortunately, that aren't took appropriate care of by their parents when they have those conditions. So then what you got brewing there, right? That's what Anne's trying to cite, that she thinks will impact the judge enough to give her a continuance. But I don't think he's going to buy it because she's been doing all the testing that she needs done and looking into his background. Now, I don't know if you got to go all the way back to great, 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 great grandpa, because she said generations. And I'm like, damn, lady, that far back? What happened to them people, right? Yeah, I get it. Oh, I know. I know Pokemon. That's exactly right, because that's what it was called, and that's what I'm saying. They don't use the term anymore, but if they did, um, It's a big difference between the mentally retarded, versus someone on the spectrum, high functioning like Kohberger. So I totally understood what you meant. Well, you never know, Rachel. You could just be some another psychotic person like the Bundys of the world, right? And the BTKs. Who knows what makes these guys tick in the end and what happened to them growing up? Were they born that way? Both the rights to a meaningful opportunity to present a complete defense. And they cite the due process case of Ake versus Oklahoma. That's awesome, Pokemon. That's really cool because it takes a special kind of person to work with those children. So, high five, Mr. Pokemon. Okay. Capital defendants are entitled to necessary expert assistance. Indeed, expert assistance is needed in all homicide cases, given that investigating a homicide is uniquely complex and often involves evidence of many different types. Analyzing and interpreting such evidence is impossible without consulting experts. Whether pathologist, really, serologist, microanalyst, DNA analyst. You're going to analyze his DNA for hereditary problems? Oh, they're just citing all the experts they need. I'm like, what? Okay, ballistic specialist. Okay, whew. I'm like, damn, lady. Okay, so pathologist, serologist, microanalyst, DNA analysis, ballistic specialist, translators, or others. The ABA guidelines 31 Hofstra L. Reverend, whatever. However, in a case where the prosecution elects to seek the death penalty, the right to access competent expert assistance is particularly important, given that the prosecution and the defense rely more extensively on experts in the death penalty cases than in other types of criminal cases. Federal death penalty case on Defender Services Judicial Conferences of the United States. Federal death penalty cases recommendations concerning the cost and quality of defense representation from 1998. Because prosecutors rely extensively on experts in death penalty cases, capital defendants cannot present their claims fairly within the adversary system if they have not also obtained competent expert assistance. Beyond the frequent complex merits phases issues, conducting an adequate investigation into sentencing phases issues in a capital case almost always requires the assistance of multiple experts. Well, doesn't she have a bunch of them already? Defendant's mental condition is seriously in question and is relevant to the punishment he might suffer. Oh, it was explaining when a capital case, not just her defendant. I had to go back and like, what? Mental defendant's condition is seriously in question is relevant to the punishment he might suffer. So she is questioning his mentality. The state must provide mental health professional capable of conducting an appropriate examination and assisting in evaluation. Psychologists or other, I'm skipping a little bit of it, y'all, because it's not relevant. Psychologists or other mental health expert may well be needed member of the defense. As discussed further in section 111E, defense counsel cannot know the full range of experts that they may need. Oh, she needs more time to figure out which other experts she needs to bring on board. Counsel's professional and ethical obligations in a capital case. Counsel's duty to provide effective assistance in accordance with the prevailing professional norms. Now, she's just going to go over all the guidelines again and the due process and all that she has to do to, help her client. The minimum requirements counsel must meet in investigating for the merits phase of the capital case. Counsel must thoroughly investigate and challenge every piece of the evidence the state purports to have. To assume the accuracy of whatever information the client may initially offer or the prosecutor may choose to be compelled to disclose is render ineffective assistance of counsel. She's about to ask for all of her experts to go up against each piece of that evidence, and rightfully so. The defense lawyer's obligation includes not only finding, interviewing, and scrutinizing the backgrounds of potential prosecution witnesses, but also searching for any other potential witnesses who might challenge the prosecution's versions of events, and subjecting all forensic evidence to rigorous independent scrutiny. I called this shit 2.5 years ago that this lady was going to take this case to the test. Sleuthy and I had an amazing conversation on Twitter one day. I used to hold Twitter spaces back in the NFT days. She was holding them over there in the true crime. We hooked up in the middle. But we had a really good conversation over there one day about this and how many times in the future, 10 years from now, Idaho versus Kohberger is going to be cited over and over and over in all these upcoming cases. Will Ann Taylor ever be able to set one single precedent in this case? In game. In addition to a complete investigation of, and y'all think these experts in Karen Reed are battling over damn digital data dates and drifting clocks and pieces of glass? Idaho Brian Kohberger case is saying, hold my beer. Y'all just buckle up, buttercups. It's coming. Other potential witnesses who might challenge the prosecution's version of events and subject of all forensic rigorous independent scrutiny. Amen, sister. In addition to a complete investigation of every piece of the state's case, counsel is then responsible for identifying and considering all legal claims potentially available, even if those claims have consistently lost in that jurisdiction. She's got a, you know, you can say she's got a lot to overcome. She's got digital forensic evidence, she's got grainy car footage, and DNA on a sheath to go up against. Let that sink in. Those searches on that phone that Dateline showed us going to even be relevant? This is necessary because counsel in a capital case has a duty to preserve any and all conceivable errors for each stage of appellate and post-conviction review. Non-preservation of an issue at the trial level may result in waiver and ultimately a defense execution even if reversible error occurred. I could tell through some of her filings, like a long time ago, it appeared to me that she was watching some of that stuff in Delphi. And I'm wondering, is she watching, gauging Karen Reed, social media impact and all that? This lady's not stupid. She's actually freaking brilliant. But I think she's got a lot of circumstantial evidence to overcome, right? And how much more they got on this guy that we don't know about, because I really do lean toward he probably did it, versus not thinking that based on what I read in these documents from both sides. But I don't know. It's going to be interesting to see where she takes all this and how far she'll get. The obligation places a significantly higher burden on defense counsel than in a non-capital case. Will Anne be able to bring up things that might make people go, "Ooh, wait a minute, like really?" You know? Wait a minute. In an ordinary criminal case, counsel could strategically forego some aspects of the exhaustive investigation outlined step by step in the ABA guidelines and would not be required to reserve every possible legal error for potential review. Furthermore, there will be significantly fewer legal issues to address because the unique issues related to a capital sentencing would be irrelevant. Counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, and compile all of this information into a cohesive narrative for the sentencing phase. Sentencing phase, if found guilty. What a constitutionally adequate investigation entails. Oh, you know it, Pokemon. She's studying what not to do. Let me watch Delphine read and figure out what not to do and what to do. Yeah. It will, Sajoy. Hippler's got this. Look, I have faith in Ashley Jennings. She needs to be a little more, bring it, girl. Bring it. You know you got it. I got faith in you, Ashley. But I like Judge Hippler a lot, and I really, really do. So I know he's got this. And you can bet he's not looking at this like we are. He's looking at this through the eyes of the law. He's only coming at this through the eyes of the law. So we have to take that for what it's worth, and just whatever he decides, he decides. A constitutionally adequate investigation for the sentencing phase of a capital case requires a comprehensive investigation into the client's entire life history in order to present a complete picture of the client's mitigating life circumstances to the jury. Hmm. Because the sentencer in a capital case must consider in mitigation anything in the life of the defendant which might mitigate against the appropriateness of the death penalty for the defendant. Penalty phase preparation requires extensive and generally unprepared. Is there like a lot wrong with him that she's got to go that far?
Isn't there isn't there a sentencing investigation that happens or a sentencing after the jury reaches their
It's
verdict? If they're found guilty, isn't there an investigation that happens after that? Isn't that the usual process?
well, yeah, the pre-sentencing and all that
Yes.
phase, right?
Yes.
And
Right.
so Ann Taylor's been on this from day one when she first filed her motion to strike the death penalty. That's how she's getting all this in because of that motion, which was her right to file that motion. It was expected. You're a death penalty attorney. You don't file that one tiny little motion, you are ineffective from that day forward. It's a normal procedure. But it's the things that she cited within that document, right? Her basis for asking to remove the death penalty. And this is a lot of that she talked about in that document. She's talking about right here. Everybody's focused on that Dateline stuff. It's coming up, but there's so much more in this document outside of that little bit about Dateline. And that part is intriguing to me because my brain has needed to be stimulated for almost 2 weeks now because it has been really unstimulated. Watching some of those experts testify over there in Karen Reed. I'm like, what the hell? My brain, I'm dying. Because the sentencer in a capital case must consider the mitigation, anything in life of the defendant, which might mitigate against the appropriate. Like, I don't why do you got to go back all those generations? To me, is crazy, right? I understand going back to his childhood, but you're going to go a step further in a minute and talk about his birth. Was his mama an alcoholic, fetal alcohol syndrome, stuff like that? She's taking a look at all of that. Do judges or do they allow jurors to consider that type of stuff, right? That a lot of people probably experienced. I don't know. I think that some of it maybe if it's like an immediate to him, right? Stuff that happened to him in his childhood, but not grandpa and great grandpa and daddy, grandpa and great grandpa. So y'all inherited the bad gene down the line. Okay, we get it. Still, you are responsible for you. Break the family trauma and all that, all the things. There's ways to do that. The defense must conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, record, and any circumstance to the offense or other factors which may provide a basis for a sentence less than death, in order to meet their constitutional obligations. So she says she's obligated, to go that deep. It's is a crazy. This filing is going to get Ann Taylor a lot of applause from defense attorneys. Compiling a comprehensive life history for a capital sentencing phase requires two primary responsibilities, which are dependent upon each other and further explained below. These responsibilities are collecting and analyzing records from the client and the client's family's life history and interviewing individuals who have touched the client's life or who may be able to shed light on circumstances shaping the client's life. What?
Wow.
Are we going to get the book on Brian Kohberger alone is going to be fascinating. If we're
Yeah,
going to go
but
that deep.
this is starting to remind me of when Judge Bareski asked Lori, "Well, what is the relevance
You
of?"
don't think Judge Hipper's gonna make one of them faces and put his mask hands up? I call it like he's that card like this last hearing when he put his like he did Spider-Man hands, right? And he put him over his eyes. Oh my God! Everybody was like, "Dude, yeah." I could just see him going, "Okay, Ann, I'll give you his childhood, but that's all you're gonna get.
Right.
That's all you're getting." If I was a judge, I predict that's what Judge Hipper's going to say. I give you his childhood. You're already delving into that. You've already talked about it in your documents. That's as far as you get to go. We don't care what grandpa did.
Right.
I mean, damn. I don't do what my grandpas did. Well, I cuss like my grandpa. I'm sorry. I take that back. I get that straight up like from my grandfather. He was a sailor, served in 4 branches of the military. Papa cussed like a sailor, and yeah, it happens. He raised a strong warrior, didn't you, Papa? It's all good. Collecting and analyzing the records from the client's families and all these people that shaped his life. Who shaped his life? The teachers that reprimanded him and got him thrown out of programs in high school. Ouch. It is well established. You know what, Anne? Actually, you're right. Life history does matter, considering this guy was kicked out of a program in high school from law enforcement because apparently he had a problem with women. So I can flip and go prosecutor any damn minute. So fight that, Anne. It is well established that life history records that must be collected include, but are not limited to, and you can't withhold that information, ma'am. You done brought it to light. All records that may be in existence, which bear or on any of the following subjects: medical history, complete prenatal. Did mama take her vitamins, y'all? Pediatric and adult health information, exposure to harmful substances in utero. Did mama drink? Did mama do drugs? And in the environment. Did y'all live in a toxic wasteland? Substance abuse history. Well, it's been said he was on heroin. Mental health history, history of maltreatment and neglect. Really? Trauma history, educational history, employment and training history, military experience, in case he's got PTSD, multi generational family history. Joe, did you fall off and come back? Hold on. Genetic disorders and vulnerabilities, as well as multi generational patterns of behavior, prior adult and juvenile correctional experiences, religious, gender, sexual orientation, ethnic, racial, cultural, and community influences. Wow. Holy moly. Hey, did you fall off and come back?
I did. I got thrown in the portal
You
and
got down
spit
that
back out.
portal.
Yep.
That damn portal. Firefly, did he eat lead paint? I'm sorry, Jesus, that's funny.
Did he
Um,
lick windowsills?
did he lick the windows? Oh my God.
Did he live under power lines?
His mother can come back with that because she actually wrote letters about it was all on Reddit. Firefly knows exactly what I'm talking about. She wrote letters to the victims in response to the Sandy Hook school shooting. She also she was wrote things about Ted Bundy and the death penalty. Go figure. Brian Kohberger's mama, but she, by all accounts, was a good lady. We don't know. Was she the one he inherited all of his behavioral problems from? The girls were daddy's girls because he protected them from that mean little brother, and mama babied him. Oh, she just described every baby boy in America. Prior adult and juvenile correctional experience. I got one of those myself. Religious, gender, sexual orientation, ethnic, racial, cultural, and community influences. Wow. So the religion's going to play a part, gender, all that, sexual orientation, your ethnicity. Oh my goodness, lady, you're reaching to articulate or events which the client knows nothing about, but which may document significant events or conditions in the client's life. See the ABA guidelines. In addition to collecting and analyzing those life history records, the defense team must identify, locate, and interview life history witnesses. Damn, like the preschool kids and stuff. Life history witnesses. Please don't bring my life history witnesses into play. I would be telling my attorney, no, ma'am, do not do that. You can't trust them people. In a, goodness. A cutlery component manner in order to produce confidential, relevant, and reliable information. Lay witnesses must be interviewed include people such as the client's family existing 3 generations back. Well, borrow the FBI's IgG tree and they've done half the work for you. Oh, wait, you got it. Which most defense attorneys don't get. You got it. Interesting. You took a look at that tree, did you? Provoke a thought? And those familiar with the client. The client's friends, teachers, classmates, co-workers, employers, and those who served in the military with the client, as well as others who are familiar with the client's early and current development and functioning medical history, environmental history, mental health history, educational history, employment, training, military experience, religious, racial, and blah, blah, blah. Social service and treatment providers to the client and the client's family members. What? You want what? Social service and treatment providers to the client and their family members. You want their medical records to look at their treatment? No, no. Including doctors, nurses, and other medical staff, social workers, and housing or welfare officials. Witnesses familiar with the client's prior juvenile and criminal justice correctional experiences. Former and current neighbors of the client and the client's family, community members, and other familiar with the neighborhoods in which the client lived, including the type of housing, the economic status of the community, the availability of employment, and the prevalence of violence. I know little towns like that, ma'am. Pritchard, Alabama comes to mind right off the top of my head. Witnesses who testify about the applicable alternative to a death sentence and or the conditions under which the alternative sentence would be served. Witnesses who can testify about the adverse impact of the client's execution on the client's family and loved ones. I'm sure it would impact them if their son was sentenced to death for a quadruple homicide that he likely committed, yet to be determined by a jury of his peers.
Well, I wonder how it impacted the families of the 4 victims.
Exactly. Thank you, sir. Thank you. Because Ethan, Xana, Kaylee, and Maddie are no longer here. And someone took their life. So I understand what you're talking about, Anne, but damn. That's okay. She's got to play it like she sees it and try. Again, the judge is going to say, I'll give you his childhood. That's it. Is it relevant? We'll see. Is it vital that the interviewer conduct these interviews in person, face to face, and one on one? And that multiple interviews be conducted, to establish trust and rapport in order to elicit sensitive information. So she needs to take time to get to know all these individuals and gain their trust. So they'll elicit sensitive information to her. See you, lady. As the mitigation investigation develops, red flags will become apparent. Indications that a particular mitigating circumstance or theme may be present in the defendant's life history. When counsel discovers a red flag, it cannot be ignored, as to do so would be the abandon of the investigation at an unreasonable juncture. The development of the mitigation investigation, including this lady's going down in the history books. I'm telling you, the development of the mitigation investigation, including the identification of the subsequent follow up on red flags, is dependent on both life history records and interviews of witnesses. These two parts function together in order to produce a reliable life history narrative. For example, records from a client's visit to the emergency room might be evidence of physical maltreatment by a parent or caretaker. Y'all got babies that been to the ER before? Out of my four, I got one. He broke his little arm at 4 years old, visiting daddy. He jumped off the bed to go get a juice box and broke his little arm. Some people have those little kids. One of my kids, he fell down all the time, right? But not to the point where we had to go get to the hospital. He just was clumsy. But what if he did all the time fall down and hurt himself to the point where he had to go to the hospital? Is that going to indicate that I beat my kid? And I don't know. Sometimes that absolutely matters. There are some kids out there that are so abused, we don't even want to think about it. I can literally bring you the stories right now of how severely some of these kids are abused, and it just break your heart. And not just one form of abuse, but multiple forms of abuse, right? I just saw a story the other day about these kids living in these damn clay tunnels, being sexually abused by the parents. The conditions were deplorable. I saw it on YouTube on some news clips. I was like, man, those kind of kids. That's the kind of stuff she's talking about here. And does that come into play in death penalty cases? Probably so, if you're being fair about it and taking Brian Kohberger out of the equation at the moment. The authors of reports and documents are themselves potential mitigation witnesses unknown to the client and the family. Alternatively, a family member recalling that the client or his family received services from a community organization when the client was young may aid counsel in finding records that would otherwise not been known to exist. If he saw a counselor in his childhood, get those records, see what they said, what was their assessment, and which will offer a third party, and some of it may not even be relevant, contemporaneously recorded insight into what life was like for the client at a very young age. Exactly. You want to see those records. What did those little counselors at the school write down? In this way, the investigation necessarily expands as new information is learned, because each record obtained will refer to other records and reports which must be obtained. Wasn't she the one getting all upset about how many terabytes, 65, that she had to go through in discovery alone, but yet kept filing motions that she wasn't getting no discovery? Or is she wanting this thing to go on for 10 years? This clinical, oh my goodness. Yeah, right? Right, Sajoy? That's a good point, right? Take these defense attorneys with a grain of salt. She's willing to go here, but you can't go there. I like that. The clinical investigation is also important because it leads to confirmation from multiple sources, both objective records and corroborating witnesses who can testify, producing a persuasive mitigation case that can withstand adversarial testing. So all these witnesses that she wants to get in contact with and all these people would only come into play during mitigation, right? And they wouldn't testify at the trial, and none of this stuff she's talking about would really make it into the trial. Only what he's given her so far. Go test him, tell me what he's got, and we'll go from there. And that's what she did. And now we're on the spectrum with some OCD and can't coordinate properly or something. Oh my goodness. What do y'all think? This is crazy. I think Brian's family has a secret in the family. He's probably related to a serial killer, Carrie, or obsessed with one. I believe I've always. Here's the thing about Brian Kohberger. I dove into that mind deep in my Discord with my girls and came to a conclusion about this guy. And just evaluating what we were reading from people like the teachers that were involved and the witnesses that were actually interviewed on the Dateline that people didn't want to believe in the beginning. Their stories were always consistent about Brian Kohberger. We analyzed all of that and we thought it appeared this guy really began to hone in on he had issues preteen, 14, 15. He gets online and he finds a community and he starts making posts. And it goes from there. Something's definitely not right in the mind of Brian Kohberger. It's not a place you want to stay long if you're looking at a serial killer's mind. And I've deep dosed some damn serial killers. That BTK dude is weird. Because it leads to confirmation from multiple sources. Both objective records and corroborating witnesses can testify. Okay, so that's where she's going with all of that. His entire life history is absolutely relevant, she says, and any and all records pertaining to all of that. My goodness. Hold on. Why won't this thing go down? There we go. Little stop. There's my little thing. I wanted to go down to the more relevant parts because reliable mental health assessments, is she's still going through all that mental health history. So is she like showing us some work product? I mean, you got a lot to go up against because you know there's something not right with your client. I mean, you can't not know it. You had him evaluated. Counsel requires additional time to fulfill the minimum requirements described above. So she needs more time to get all of that finished that she was just going through. Counsel cannot review all of the relevant discovery and complete the necessary investigation prior to trial. Okay. I think we get the gist of that. Let's move down because it's already 119, and I know that I will post the link directly on the YouTube channel, guys, to this entire document. And everybody can read it if you want to go deep dive it. Dramatic reenactments and animations depicting the alleged crime. What? Hold on. Okay, here we go. I missed the big part that I wanted to cover. Let's get to this. Let me get a drink of my drink, guys. Hold on. Okay. The continuance is also necessary to investigate the remedy to the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline NBC special and the forthcoming book. Well, she failed to get the DP off the table due to trying to get the prosecution sanctioned, which was cited in Lori's case because Lori succeeded. The judge also cited in Lori's case all the pretrial high publicity. Two things. Prosecution didn't turn over discovery on time, didn't meet their deadline, and he also cited this. Not to this degree. God knows. That was intense. Okay, this case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9th, just 2025, just weeks before this capital trial was set to begin, Dateline aired a two-hour episode about this case titled The Terrible Night on King Road. The program includes details and materials including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The show repeatedly emphasized the non public nature of this information. Yeah, they did, stating it was obtained from unnamed sources who are close to the investigation, and the materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. Now ask yourself, is some selfies of you in a hoodie and a bunch of college students, considering you're a college student, that you were browsing, is it relevant? Will it make or break the case? The leaked materials appear carefully curated to promote a narrative of guilt. As this court acknowledged in its May 15, 2025 document and records holder order, the source of the leak is most likely someone currently or formerly associated with law enforcement or the prosecution team. If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence. Oh, holy hell. Damn, Ann Taylor. That's a pretty good statement. I like that. I hate to say it, but that's about probably all she's got. Now you've done messed with the integrity of the case. You got a rogue cop on your hands. What's he willing to do? My, my, my. I see you, lady. Mm-mm-mm. Dateline, can we side-eye you now? We saw what you did, particularly those who may be called as witnesses. The identity of those involved, their motives, and any efforts to conceal their conduct go directly to the heart of the witness credibility and the integrity of the state's case. The apparent leak is not only an egregious violation of the court's non-dissemination order, it enabled Dateline to gild rampant speculation with a veneer of credibility. When purportedly exclusive information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the investigation, it carries a heightened aura of credibility and secrecy that can deeply influence public perception. I'd say that it did. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, leaks framed are exclusives are perceived as uncensored truths that the public was not meant to see. This insider framing enhances the material's persuasive power, suggesting that it is both authentic and revealing of the case's hidden realities. The episode includes such things as repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motive, dramatic reenactments and animations depicting the alleged crime, created by the show's producer without basis in the evidentiary record. You seen some of them on the YouTube, lady? Pretty decent. Emotional interviews with individuals connected to the alleged victims. Mm. Oh, and you went there? Damn. Emotional. I don't even like reading that statement. It kind of makes me on fire a little bit. Like, lady, I want to like elbow her ass. Cut it out. Because that doesn't impact me. I've had this talk with somebody that, we talk about the Idaho 4 case, and I, I see what the families say, but it doesn't impact my decision on the case, right? I can compartmentalize that. But maybe some people are influenced by it because it seems to trigger the shit out of some people. Actually, come to think of it. Emotional interviews with individuals connected to the alleged victims, accompanied by evocative music, photos, and videos designed to elicit strong emotional response. Y'all, that dramatic music, y'all know it. You know it well. The broadcast repeatedly bolstered its speculative claims through the use of so-called expert commentary. You mad at the production or you mad at the material, ma'am? Including individuals identified as law enforcement professionals and academics. These commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court. Well, personal history, aren't you investigating that? Bring it. Oh, my dog is going off. It responded to that. While the program repeatedly emphasized their training, research, and years of experience to lend undue credibility to the conjecture. This type of testimonial mimicry improperly mirrors expert witness testimony in trial setting without the safeguard of cross-examination of evidentiary standards, effectively presenting the public with one-sided, unvetted narrative that shapes juror perception before any admissible evidence has been presented. Whoa. Do y'all think that have really had a huge impact in what will the judge do? Hey, Dolphin, check it out. Hello, ma'am. We miss you. We hope you were having a fabulous time. You haven't read it yet? I was going to message you later and say, hey, when you get a chance, check it out. I'm glad you're doing good. Good to hear from you. All right, welcome in, Jeff. Welcome in anybody that came in while I was reading. I apologize, I've been reading. While the program occasionally inserts disclaimers such as "we don't know what happened," these brief caveats do little to mitigate the cumulative impact of an extended narrative constructed through selective imagery, emotionally charged reenactments, and detailed speculative descriptions of the crime. When viewers, remember, he sat down in the chair and left blood on the seat. I don't know if I needed to know that yet, but okay. That honestly, what that did for me was really jam up that timeline. Come on, he sat down on top of everything else in that limited time. Damn, fucking ninja. An occasional passing verbal disclaimer function. That was what I took away from that whole piece of evidence. Sorry. Uh, an occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on prejudicial perception, and most viewers will leave with the impression that they have seen a reliable reconstruction of events. Well, some of us don't agree with some of those reconstructions, but okay, I understand your point. The Dateline special, which aired just weeks before the trial date, will not even be the last pretrial media bombshell. Best-selling crime author James Patterson has written a book. Uh-oh, my thing skipped. Where'd it go? Has written a book about the murders titled The Idaho Four, An American Tragedy. Scheduled for release July 14th, 2025. Just 16 days before jury selection is slated to begin. Yeah, I don't blame her on that one. I don't understand what you're writing about at this point. A preconceived notion? Yeah. Now you are the jury. The evidence is in. The publisher boasts of an unmatched access to the investigation. Wow. Really? Including interviews with local law enforcement. This suggests that the apparent Dateline leak was not the only violation of this court's non-dissemination order. Holy shit. And Taylor. Y'all, she's bringing it at the moment. Remember, all she's trying to do is get the DP removed for a lesser sentence, life in prison. We'll take it. The 16th and 14th Amendments guarantee the right to a fair trial by an impartial jury. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial effects of such inflammatory pretrial publicity occurring so close to the current trial date. In Shepard versus Maxwell, the Supreme Court held that a defendant was denied a fair trial due to massive, pervasive, and prejudicial publicity that the trial court failed to mitigate. Uh-oh. That one's worth looking into. The court emphasized the trial judge's responsibility to ensure the defendant receives a fair trial, free from the influence of prejudicial media coverage. The court explicitly noted that a continuance may be required to protect the defendant's rights. But there is a reasonable likelihood that prejudicial news prior to the trial will prevent fair trial. The judge should continue the case until the threat abates, or transfer it to another county not preempted with publicity. Well, you can't do that. You've already, well, I guess you could. I don't know the law on that. That's weird, but you already did it once. You already moved it to another county. So you want us to wait until the media dies out, until the threat abates or transfer to another county. Okay. Okay. Shh. Y'all stop talking about it. Just stop talking about it so the case can proceed. Well, okay, we'll see you on that. We'll just read documents instead. The court has likewise recognized, as my commentary, like, I'm trying to be pro defense too, Ms. Taylor, so don't take offense to none of this. The Supreme Court has likewise recognized that the passage of time can significantly reduce the taint of media exposure. That even in a case involving extensive coverage of a confession. Joe, did you hear that? Joe, are you still with me? He portaled out. Oh, goodness. She cites a case in Patton versus Holding. This is just reminding me of another case, that's all. That even in a case involving extensive coverage of a confession, the delay between media saturation and trial reduced its prejudicial impact. Pretrial publicity did not impair juror impartiality, where by the time of trial, the news value of the original disclosures was diminished, and the newspaper items were often related to the inner pages. So you want it to go away and not be the top story. Go fall into the inner pages. Gotcha. The court has recognized that while pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, the trial judge has a major responsibility. The measures a judge takes or fails to mitigate the effects of pretrial publicity may well determine whether the defendant receives a trial consistent with the requirements of due process. Nebraska versus something Stewart. Okay. The timing of the trial is a key factor in ensuring jury impartiality, as emotional intensity and memory of prejudicial material tend to fade over time. How much time is your client willing to sit there and wait? That's my big question. He's willing to wait a long time. Social science research supports this position. What will that do to his mind, Anne? Oh boy, is that coming next? The amount of time my client has sat in a county jail. Social science research supports this position. A comprehensive meta-analysis found that pretrial publicity significantly increases the likelihood of conviction, but that the effect is diminished when there is temporal delay between media exposure and trial. Well, maybe they ought to issue a notice for everybody to stop talking about it. No media at all. Blackout? You want a blackout? Isn't that unconstitutional in itself? A total media blackout. Lady. Let's see you in the Supreme Court. In sum, 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary. We slept at Holiday Inns last night, lady. It's all good. All timed to air just weeks before trial, when juror impressions are most vulnerable and voir dire least equipped to neutralize such deep-seated bias. Wait a minute. Remember your big deal about those jury questionnaires. Voir dire, ma'am. That was a huge deal. You got your way on that too, I might add. 2 wins for Ann Taylor. IGG, jury questionnaires. The forthcoming book by James Patterson, and got an expert to boot on that very subject. All time aired just weeks before trial. when juror impressions are most vulnerable in voir dire, least equipped to neutralize the impact. Okay. Um, the following forthcoming book by James Patterson, which will arrive in the hands of potential jurors just 2 weeks before voir dire begins. Well, they're supposed to tell you if they read it or bought it or whatever or got gifted it. Promises to set off a new round of inflammatory negative coverage and to deepen the pervasive bias against Mr. Kohberger on the eve of trial. On the eve of trial, because of the jury selection, the news will heighten during jury selection. Mm. Welcome to the world of high profile cases for real. Ann Taylor says, hold my beer. Karen Reed in Delphi. The court has already acknowledged that the Dateline special exposes a likely violation of the non dissemination order, and Mr. Patterson's purported unmatched access to sources, including local law enforcement, suggests that multiple unauthorized disclosures have occurred. It would appear that way. Depending on the results of the investigation into the leaks, a continuance may be inadequate. A continuance may be inadequate. What would be adequate? Where are we going, Ann Taylor? Once the source of the leaks are identified and the full extent of misconduct revealed, the violations could warrant remedies more serious than delay. At the very least, however, a continuance is essential to allow the extremely prejudicial impact to partially subside and to give the court and the defense time to fully investigate and address the scope of the violations. Only then can the conditions necessary for selecting an impartial jury and ensuring a fair trial under the 6th and 14th Amendments be meaningfully restored. Wow. I don't. She wants the death penalty taken off the table with all that um, family history she's wanting to delve into. But where is she going with this? Right? Reversal is more likely than not in any case resulting in a death sentence. Statistically, almost 2/3 of death penalty cases are eventually overturned due to errors, often many or even decades after the initial conviction. A frequent cause is reversal of ineffectiveness grounds due to the lack of an exhaustive investigation and complete presentation to the sentencer. Hundreds of cases could serve as examples, but for brevity, the following are examples from the United States Supreme Court and the Ninth Circuit, courts that will have judicial jurisdiction over the review of this case in the event of the death sentence. And she's going to go through and name these cases and their relevance to Brian Kohberger. Affective psychosis, very pronounced trauma, evidence regarding defendant's mental capacity, family background. Yeah, any case she could dig up that nightmarish childhood, borderline mental retardation. Wow. Guys, again, I will post the link to this large document, I promise. It's 1:40. Joe goes live in like 20 minutes, and I am going to go over there and co-host with him. Tomorrow there's a day off in the Karen Reed case, and we're at page 38 of a 40-page document. So I will drop the link to it, I promise. Mr. Kohberger deserves a fair trial from the outset to prevent an arbitrary or wrongful conviction and potential death sentence. These cases underscore the critical importance of thorough investigation before trial. This diligence is essential to avoid the costly and time-consuming process of reversing a conviction and death sentence years or even decades later. Hey, Miss Shorty, I've missed you, but I know why, and it's all good. I got to come do my weekend at Camp Shorty's and get my strong bitch on. I love you, lady. Logic that the argument would mean she needs to speed up trial to start it, not delay, right? I know, she's got, wow, careful, Anne. I'm just looking at you guys' comments. So everyone watched the Dateline episode is now convinced he's guilty. I don't think so. People make up their own minds. Yeah, Jeff, you would hope that most people do, right? but how many of those people were impacted by what they saw? You know, um, it of course is impactful and makes you go, and you side eye that shit, right? But we all know at the same time we shouldn't know what was on that dude's phone. Somebody shouldn't let that cat out of the bag yet. It, you know, but is any of that relevance the question? Photos of you, your photos of your selfies in your hoodie. Is it relevant to the case? Really, from a legal standpoint. And then the browsing history that showed all the photos. He's a college student. Was he just looking at random college places and papa, these photos were all there? I don't know, right? How much weight does that bear on a jury? So anything she can do to keep, and anything you can bet any of that stuff that was shown on that dateline, she's going to want to keep that particular stuff out. Meaning those selfies and anything else you saw on that dateline, she's going to want to keep that stuff out now. Mr. Kohberger deserves a fair trial from the outset to prevent any arbitrary or wrongful conviction and potential death sentence. These cases underscore the critical importance of thorough investigation before trial. This diligence is essential to avoid the costly and time consuming process of reversing a conviction and death sentence years or even decades later. Continuance is reasonable and necessary under the circumstances. While there is no mechanical test for determining whether a continuance should be granted, a trial court cannot deny a continuance based on a myopic, myopic that got me tongue tied, insistence upon exped, exped, my God, I can't talk all of a sudden. I need a drink. Expeditiousness in the face of justifiable request for delay. In determining whether denial of a continuance request resulted in a violation of due process. So she's going to, you know, if you don't give us this, judge, it's going to be a violation of due process because we didn't, it wasn't dealt with properly. Whether denial of a continuance request result in a violation of due process, the reviewing court looks to the circumstances of the case. This request is not made lightly. The defense counsel has worked around the clock actively preparing for trial since appointment of this case, filed all motions in a timely manner, complied with expert disclosure deadlines, and had expected to proceed on schedule. However, it has become clear that without additional time, the defense cannot complete review of the necessary discovery, meaningful respond to all of the state's amended expert disclosure, and incorporate the information into an effective defense. The finish critical sentencing phase investigation. While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. And because the majority of cases ending in the death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. Amen, sister. A continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts and not forced haste. Phew. It's been a minute since I read one of these damn documents. They file long ones in Idaho 4. All right, guys, that was the end of that. What do y'all think? You think she's going to get a continuance based on the dateline stuff? Phew. She's been whining about needing more time. She'll likely get it now. Yeah. She's been doing that, right? All along. Complaining about all those terabytes she had to go through, but that she received in discovery, but at the same time she doesn't get discovery. So we're like, what up? Oh my goodness. But yeah. What? Is that really what they're saying? Is that really what they chose to put as like a headline thumbnail? Wow. Are people out to throw this case? I'm just saying. I'm asking for a friend. Hmm. You got me curious now. Okay. saying that cops are leaking the knife is in evidence. Well, everybody's been speculating about that since the judge said what he said, right? Oh, okay, I will scroll up. I look, here's the thing, right, Miss Shorty? If you know, you know. I could say a couple of cases out loud, but I won't. And I'm not talking about Karen Reed, everybody. Good Lord. Maybe I am, maybe I'm not. No, that's a joke. But yeah, you can't, you dance with the devil, right? I hear you. I hear you, sister. Mm. Okay, I got you. Oh, let me see. I'm looking at it now, or on the YouTube channel. Oh goodness, that was. Oh, okay, 6 days ago. Okay, I'll review later. Let's see, Dolphin. He hasn't. Did anything come down? Let me. All right, guys. Got 10 minutes or so before Joe goes live. Let me check the docket. Did something come down, Dolphin? Is he ruled already? No. That was just her motion to continue that was dropped. I think it was yesterday. Um, they filed a motion. These three came onto the docket yesterday, or on the 20th, and then the 21st another one was entered. But what they are was they filed a motion for leave to exceed the page limit. The defendant did, and they got the order granted, and then this document dropped, which was the defendant's motion to continue, and it was a 40-page document. And I just read, I'd say 90% of it. So I'm kind of like, um, yeah, ever since the judge said that about how the jury could handle evidence, right? The physical evidence. And he began to talk about a display box, like a clear, and he gave two examples about what could be displayed in there. Two that I remember. He said a gun, or for instance, a knife. And everybody was like, what? A knife? I was like, but was that just an example, or was he telling us something we might want to hear, right? I was like, So that's when everybody was like, oh, they got a knife. But if you go back to the Pennsylvania search warrant return, the very first item listed is just KNIFE, knife, undescriptive. The other knives they found they have a description, right, Dolphin? That's it. So I don't know. Lolo Mountains, did they recover something we don't know about? But is law enforcement leaking that kind of information? That I got a problem with that. I really do, because this lady's not wrong about some of the stuff she said when it come down to the pre-trial publicity stuff. Um, I got a little problem going all the way back to great grandpa and everybody about your mental health and all that, but whatever. That aside, mm, you're pushing it to what extreme are you going to push the Constitution? And how far will you take this pre-trial publicity stuff? And there's a lot of stuff that if the judge has this order in place, damn, if you get caught, if you think about that, if you're the one that did it, holy shit, what are you thinking right now, right? Are you about to do what happened in Delphi? If you know, you know. The leakers, sometimes things don't end well for those people who leak. They grow a conscience afterwards, and bad things could happen. Damn it, man. Was it worth it, right? Was it worth putting the highest, I'll just say it because I think it's going to be, regardless of the two happened, that, Delphi and Reed, they're both huge. This is going to be even bigger, all because of the stuff she's doing, and she has the right to do a lot of it, but a lot of it, is it true? The social media impact, the mainstream media impact, what does that mean? And how many people actually consume that stuff, right? Um, there's a good majority of people who don't. Not everybody's like true crime in it like we are. Do they even watch the evening news anymore at home? Things like that come into play. That's the importance of all those juror questionnaires in the end. And she has spent a whole lot of time on juror questionnaires and what she's allowed to ask them. They were asked in Idaho before it got transferred, right? Dolphin, help me out here if I'm not right. But they wanted to send out those questionnaires to question everybody there about what they have heard specifically, right? And did you hear this? And have you seen this about? And all these things have to be asked. So would it be that hard? Would people lie just to get on the case? I have never heard of this case. I don't watch the news. I'm busy. I don't really hang out on social media. I don't know. Yeah. Can you imagine that? And of all people, right? I thought you had some integrity, man. I can't bring myself to do that stuff. I can't, like I said earlier, I can't use like the AI image of Kohberger because it doesn't look like him to me. And I'm trying not to be a part of the problem, maybe part of the solution, maybe I'm dreaming. But I just gave that document a fair review, I thought. Agree with me or don't, but I was like prosecution and defense at the same time, coming in hot. Yeah. Anyway, there's a link to Joe's live, everybody. Thank you for tuning in. And it was a nice true crime break from the other case to focus on something else for a minute. Appreciate everybody coming in, hanging out with us, and I'll drop the link to the document into the channel in just a few minutes, and I will be going over to Joe's in just a minute to co-host with him, so I need to take a break for about 10 minutes. So thank you guys so much for coming in. I appreciate it. Y'all have a good
all
one.
for watching this here video. Please like and subscribe and follow. Much love from little Yas to each of you.